Item 19 of Part 2 hearing list. Your Lordship, with the consent of the other parties, if this matter may be taken on 18 of August.
Item number
19 of Part 2.
19 of Part 2.
Yes, Your Lordship.
This is a criminal appeal.
Yes, Your Lordship.
You have informed the PP? Have you informed the PP because this
Yes,
is a
Your
fixed
Lordship.
matter?
Yes, I've taken the consent of the other parties.
Okay. Both sides are represented on the prayer made by Land Council for the appellant. The matter stands adjourned today. List on when?
18, Your Lordship. 18 of August.
Okay.
Lordship, I beg to mention item number 11, Lordship. Item number 11, Lordship, I mentioned it, Lordship. Lordship, in this case, Lordship, my colleague informed that, Lordship, the learned special PP, Lordship, he is undergoing treatment, Lordship.
Yes.
Daily list item 11.
Daily
Huh?
list item 11, Lordship.
You want an adjournment?
Lordship, I was informed by my colleague that learned special PP is undergoing treatment, Lordship.
Okay. Okay, both sides are represented on the ground that the learned special PP is unable to attend the court today, the matter stands adjourned today. List on
Any day after next week, my lord, if that's possible.
agree to a date.
24th of August.
24th. Deeply
Obliged.
obliged.
Daily
May I
list.
plead, Lordship?
Yes.
Lordship, with the consent of the other side, I beg to mention item number 8.
You are appealing for?
Lordship, I am appearing for on behalf of SK Medhi for respondent number 1 and 2. Lordship, my senior, he is not well. He is suffering from fever.
Okay, all sides are represented. On behalf of,
My lord, if I may, I am for the petitioner. My learned friend has not taken the consent from me before.
Okay.
Even though she has just made such kind of submission. She has not,
you have not taken consent.
yes.
Yes, you made a wrong statement. You did not take the consent of the petitioner.
Lordship, I was informed that he was informed.
I was not informed.
Maybe somebody must have been told. She is making a repeated statement. Okay. Yes, when the matter can be fixed?
Lordship, can it be on Monday, next Monday?
Yes.
My lord.
Okay, both sides are represented. On behalf of the Mr. S.K. Bedi, on its CGC, it has been submitted that he is unwell. So accordingly, matter stands adjourned today. List on, make it next Monday, 17th.
Obliged, Your Lordship.
Much obliged.
Daily list promotion, item 1.
This petition is for modification of this honorable court order dated 8/6/2026, passing criminal petition number 10 of 2026 for release of the seized currency. Then, my lord, today is the first time, and if notice may be issued.
This petition cannot be entertained in this manner. You want a modification of the order of this court. It can't be done by filing a criminal petition. We can understand if you want a modification of the order by filing an interlocutory application. But can the order of this court by the learned single judge be quashed or modified under 583?
And also, the order passed by the
Sorry,
special judge
528.
and the NPS Act.
No, but bail condition has been imposed by this court, by the learned single judge. Can we touch that order under 528? And secondly, amount of rupees 24,50,000 was seized. Will 1 lakh rupee surety suffice for 24 lakh rupees? Now let us assume that this 24 lakh rupees is released to you. You now come and say that, well, I am ready to pay 1 lakh rupees, but 24 lakh rupees I don't have. What would happen?
So, my lord, if in the 1 lakh any other
We
amount-
understand, but tomorrow only you are coming back. I can see the future. Today we are passing an order altering this 24 lakh rupees to be released on surety of bank guarantee to one of 1 lakh rupees. Tomorrow only morning you are coming that I am ready to deposit 1 lakh rupees, but 24 lakh rupees I have spent.
My lord, my senior, who is the leading counsel, is out of station, and if the matter can be taken on Friday.
You took a risk of opening up. This can be done in a manner. Bank guarantee is not a substitute for 1 lakh rupees for a sum of rupees 24,50,000. Where is a statement that you have assets and properties more than rupees 24 lakh? That your assets are worth more than 24 lakh rupees. Where is that statement? We did not find it.
My lord, the petitioner in paragraph 3 of my petition, we have stated the petitioner has immovable property.
You see, no. You have written very carefully of this. This petition is very craftily drafted. Come to page 6. Paragraph 4. It is most respectfully submitted that since the petitioners are financially incapable of giving security, that means your assets and properties are not worth more than 24 lakh rupees, otherwise you would have got the bank guarantee. Okay, both sides are represented. The learned counsel for the petitioner prays for adjournment as the learned counsel holding the brief is not present. Next para. On the next date, the learned counsel for the petitioner shall address the court as to whether it would be permissible to modify the conditions of the order dated 8/6/2026 passed by this court in criminal petition 10 of 2026 in an application filed under section 528 of the BNSS. First of the said order was applied by the learned special court within bracket NDPS Act bracket those ISOL in its order dated 16/7/2026. Next paragraph. The petitioner in paragraph 4 of this petition has stated that the petitioners are financially incapable of furnishing security. Therefore, comma, the court is of the considered opinion that a bond of rupees 1 lakh would be too insufficient to release a sum of rupees 24,50,000 to the petitioners seized in connection with SR number 417/2023 under section 21 within bracket small c of the NDPS Act. And moreover, there is nothing in this petition which suggests that the net worth of the petitioners is more than rupees 24,50,000. Next paragraph. Be that as it may, on the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List on
Friday, 14 August.
okay.
That applies.
Item 2.
Yes.
May I please your lordship, my lord, this contempt petition is due to non-compliance of the judgment order dated 17/3/2023 passed by this honorable court, whereby the petitioner
Which page is that order?
the order is in the contempt petition.
Which page is that order?
The relevant portion is in page number 47. The judgment starts from page number 10. in the contempt petition. The contempt petition filed on 29/9/2023. The petitioners were members of the Petitioners Association were members of the Sarvasik Abhiyan. The direction, the relevant portion is in para 23, page number 47. Have you got it, my lord? Para 23.
But in the affidavit filed by respondent number 5,
Yes, your lordship.
they have said that this scheme would be applicable to the petitioners.
My lord, I'll come to that, my lord. Before I pursue with my submission in the present contempt case, my lord, what I would like to submit before your lordship is that recently the state respondents had filed IA number 28 of 2026, seeking for extension of time for compliance of the judgment. And the same was recently disposed by this honorable court on 23/7/2026. I place in the order, my lord. I'll take your lordship to the relevant portion, para 7. They have sought for extension of time for compliance of the judgment order. The judgment order was 17/3/2023. May I read para 7? On consideration of the submissions made by the counsel for the parties, this court finds the following. As has been stated above, the specific direction of this court by order 17/3/2023 was to the effect that members of the petitioner association who are working as teachers under SSA should be considered for regularization against the existing vacant post of government teachers in appropriate grade, in tune with the object of the Right to Education Act, and it has only in the alternative that this court had held that government should sanction new posts as SSA teachers by creating the respective cadre. The additional direction given by this court was to frame a scheme for regularization of the teachers if the state government finds it fit, and it was further directed that the exercise should be completed within a period of 6 months. However, it is seen that the state government had not followed the directions within the time frame, and after a period of more than 1 year from the date of passing of the judgment had published a scheme. The name of the scheme itself suggests that the same is applicable to all the employees working under the CSS, and it is not specifically meant for the petitioners, whereas the directions were given in respect of the petitioners by this court. The contention of the Learned Council for the petitioner that the scheme will also include the teachers who have approached this court will also not suffice the requirement in the order dated 17/3/2023. The various other exercises conducted after the scheme has been framed and published is also not in response to the direction given by this court. The said exercises were conducted for the employees under the CSS, and the gamut of the entire exercise seems to be very large, since there are 6,000 and odd employees, as has been stated, under the said scheme. My Lord, the present petitioners association were consisting of 1,356 at the time of filing the contempt petition. And this judgment, 17/3/2023, has not been, no appeal or review has been filed. The same has now attained its finality. But, my Lord, besides applying this application for extension of time belatedly, my Lord, what the state respondents had done was that they have their own agenda. They have willfully disobeyed the direction of this court by, during last year, 2025, they have recruited as many as 1,024 casual teachers on different capacity, ignoring the direction of this honorable court. And at present, my Lord, there are as many as 2,735 vacant posts, as per the RTI information I received recently. And the state respondents have now been taking active steps to fill up as many as 312 posts on open advertisement direct recruitment, without intending to consider the case of the present petitioners. Now, the present respondents, contenders have already filed the respective affidavit, and I have already filed my reply affidavit also, my Lord. Unless this honorable court is inclined to pass an appropriate order against the contenders, my Lord, they have no intention to comply at all, as directed by this honorable court. This is a judgment of 17/3/2023. All those steps which were stated as steps taken by the respondents were not in respect of the present petitioners, but those are the blanket steps which even this coordinate bench in the IA also do not accept it. So far as the posts are concerned, my Lord, there are clear-cut vacancies, but they have intended to fill up by way of open advertisement, instead of first considering the case of the petitioners.
Yes, you are appearing for all the respondents.
Yes, Your Lordship. Your Lordship, which my learned friend have pointed out the observation made by the coordinate bench of this honorable court in the IA. However, my learned friend have missed out the last portion, which stated clearly that this observation made in this order will have no effect on the consideration of the contempt application. Your Lordship, what I would like to submit is that, yes, we have taken steps. At first, we are trying to comply with this order. And then since the volume takes time and scrutinization of numbers of employees took time, we have sought for an extension of 2 years' time. However, that was dismissed, admittedly. Your Lordship, in between, we have taken steps. Now, a study group was, in view of the scheme, a study group was formed, as we have already submitted in the show cause reply affidavit. And the study group, what is missing from the affidavit that we have already filed is that the study group has already submitted their report to the government, and they were differentiated into a phase. Phase 1, phase 2, phase 3, etc. Now, phase 1, it's almost completed their regularization. Phase 1 is concerned with the teachers of special special teachers for
Those were not the petitioners.
no, Your Lordship, they are
Please don't
members.
interrupt.
Yes,
That's not a good habit.
they are members of the association, Your Lordship, and
We
Your
don't
Lordship.
need a running commentary. Yesterday also you were saying we did not say anything, but please don't give running commentary. Correct? It shows disrespect to the other side. And number two, you are distracting the court from understanding what she is making a statement.
And
It's
Your-
absolutely not taken in good taste.
And Your Lordship, after that, it makes the state rethink of the steps that we have diligently thought that we were taking, and now we have filed the appeal at this belated stage, which is yet to be listed, Your Lordship. I have filed the appeal on 30/7/2026. Which is yet to be listed. I believe that in the next sitting it will be listed, Your Lordship. However, there is a delay of 1,109 days in preferring the appeal. And Your Lordship, rightly or wrongly, we have pursued the matter. Maybe there is a delay, Your Lordship. Now, with regards to the contempt, Your Lordship, at this stage, what I would like to pray is that to put on record whatever steps that we have taken by way of filing the additional affidavit, because this contempt,
You should have done it earlier. This is a contempt of 2023. And when this coordinate bench arrives at a finding that you have not done anything and therefore extension of time is refused, a case of contempt is made out. If you are not showing us what is there, we will initiate the contempt. We have got no other alternative.
Your Lordship, I can, if I can produce the, I have it in hand before when the matter was taken up in the IA, the confidential file also, wherein we have taken steps. I can produce that also, Your Lordship, if so required.
That is not reflected here.
Because that is how we took steps in scrutinizing the in compliance of this honorable court order at that point of time, Your Lordship. Now, Your Lordship, the team.
Scrutinizing the records is something else. To say that we have been working on it is something else, but it must translate into something very concrete. Because this court has rejected that contention that this was the action you had taken was in accordance with the order of the High Court. That contention was already rejected.
Your Lordship, the documents that I have had in my hand was not produced by the coordinate bench of this court while dealing with the IA 28 of 2026.
What you see in a contempt petition, can you be permitted to file affidavits and add on and then change the contour of your affidavits at the stage when the court asks you as to what steps has been taken?
Your Lordship, we are not changing. We are just the latest that we have filed in the show cause affidavit is the constitution of the
Please give
study
this
report.
record of IA 28. Have you spelled out that action taken there?
Yes, Your Lordship.
IA 28.
However, some are confidential, so we have made a statement that since it's confidential, we are ready to submit.
In the process, you have damaged your this appeal which you have filed. You know what you have done in this IA? You have a copy of this?
I do not have at hand, Your Lordship.
You don't have.
It's already disposed
See this
of.
paragraph 4. Read this subparagraph 4.
Yes. As the state applicants respondents have already discussed in a meeting held on 22/5/2023, as mentioned above, it was not in a position to bear the extra financial burden due to fund constraint, and it would far-reaching implications to all CSS members besides the present respondents petitioners. Hence, decided to prefer an appeal against the judgment and order. However,
After that,
yes, after that, decision to retract the decision made earlier and not to file the appeal, after all, was made on so and so in light of the decision taken by the meeting of the councils of ministers, Your Lordship.
even after that,
And draft letter was sent to the Learned Advocate General on 30/11/2023.
to file an appeal.
Yes. After
So
that, it goes to
therefore, your instructions were sent in November 2023. Still, the appeal was never filed. Do you have a case for condemnation of delay?
Yes, Your Lordship, we think so, because we were diligently pursuing the matter by
Well, we are not
by
commenting. This is
trying to let them cover
we are
the
not
scheme.
we are not taking up your appeal
Yes.
or your condemnation application. But this has brick by brick demolished everything. So therefore, there are two things which come out. Number one, this financial incapability of the state to comply with the order of the court. Second is that the counsel for the petitioners is now saying that you are undertaking new recruitment. So if you can do a new recruitment, why you can't absorb those who have already been recruited? There's
Your
no answer to
Lordship,
that.
yes. Your Lordship, it's in the process. The problem was that some of them, they were not recruited against a sanctioned post, and they are not recruited against advertisement or open advertisement.
That's never your stand.
So that was our grounds of appeal, Your Lordship. At first, we were trying to make the appeal. However, it was decided that appeal should not be filed. And then
It's not your,
compliance
you see, the salary comes from whom?
from the government, Your Lordship.
The
present.
central government gives you reimbursements.
No, Your Lordship, at first, in the ninth 5-year plan, the ratio was 50/50, and from 10 5-year plan, it was, if I'm not mistaken, it's 90/10%.
So
10
whatever will be the equation of the sharing, you make the payment and you are reimbursed the
No, Your
central government
Lordship,
share.
since 2017, that has been stopped.
There is no reimbursement under the central
No, Your
fund
Lordship.
scheme.
No, Your Lordship.
So
As far as my
how would you
knowledge is
be how would you be paying someone without without a regular appointment? That means there is no
From
checks
the
and
state funds, yes, from the state.
that means there is no checks and balances when you are paying salary. Anybody with a manufactured appointment letter would be getting his salary. That can't be. You never took steps against those persons who have appointed people without there being a sanction post. And you have never applied for the modification of the order of this court because the learned single judge in the order has not recorded that statement that people were appointed without there being a sanction post.
But it was a stand before the, when the writ court was under consideration, however, it was not recorded.
We think that a case has been made out for issuance of a contempt we initiate the contempt issue show cause notice as to why punishment should not be.
Your Lordship, that is why at least I would like to pray for an opportunity to at least lay out the all the steps that has been taken after we have already filed the show cause reply affidavit, because another steps has been taken. This was the steps taken till 2024.
That has already been rejected by this court as not in compliance with the order. How will it help you? Supposing we give you that opportunity, the only document you are producing is that which has already been considered in this interlocutory application.
Your Lordship, in my to my limited knowledge, Your Lordship, how to deal with the contempt petition will be totally different with the IA, because in the IA, after lapse of almost 3 years, we have sought another 2 years for extension of time. So it was rejected. But however, in civil contempt, Your Lordship, we have to prove they have to prove the willful disobedience and negligence, etc.
You are forgetting a small principle. You see, when you make a statement even in an interrogatory application that is supported by an affidavit, this order may not influence us, but the fact remains that this court has rejected it. So that part we can always take judicial notice. This order will not have a cascading effect on that in the contempt petition. But what happens to your pleadings already made? Can you disown that pleading merely because this court in this IA has stated that this will not affect the contempt petition? A finding is a finding. It may not affect the order, but definitely it will bind this court. The court cannot give an inconsistent finding with regard to your 2024 steps. That in IA the finding is X and the finding in this contempt petition is Y. That cannot happen.
Your Lordship, at least my prayer be recorded, Your Lordship.
Yes, we give her 1 week time to file an affidavit, bring it on record. 7 days time, no more.
Yes, Your Lordship.
Both sides are represented. You are Miss Marielle.
Yes, Your Lordship.
Miss Marielle Kante, Khiangte, Learned Government Advocate. Praised to give an opportunity to the respondents to file an affidavit to bring on record the nature of steps taken by the respondents in purported compliance of the judgment and order dated 17/3/2023, of which contempt is alleged. Next paragraph. Mr. V.L. Ralte, learned counsel for the petitioner, has referred to the order dated 23/7/2026 passed by this court in IAS Civil 28 of 2026, and it was submitted that the plea taken by the state respondents in connections with the said interlocutory application had been rejected by this court. And this court did not find any sufficient cause to extend the period for compliance of the order dated 17/3/2023. First of it is submitted that that in the said order dated 23/7/2026, this court had taken a view that no concrete steps has been taken by the state as the present petitioners were not considered for regularization of their services as ordered by the court, despite lapse of 3 years from the date of the judgment under contempt. Next. Be that as it may, as prayed for, a last opportunity of 1 week is granted to the respondents or any one of them to file an affidavit as prayed for. Okay, we have said as prayed for filing an affidavit. Next paragraph. It is made clear that if the affidavit is not filed within the time allowed, the court would hear the matter on the basis of materials available on record. The affidavit shall be filed within 18/8/2026, expire list on 20/8/2026.
Item number 3.
That IE petition is there.
Understand for respondent number 5.
This will go in the contempt petition. Yes.
Your Lordship, on behalf of the state respondents number 1 to 4, I am yet to receive instructions from the concerned departments. If Your Lordship permits me another 3 weeks' time to get the instructions and file my affidavit.
You're praying for how much time?
3 weeks' time, Your Lordship.
Can you take out your mobile and do some arithmetic for me? You can pull out your mobile and do some arithmetic for me.
Yes, Your Lordship.
The claim here is of rupees 1 crore 74 lakh 62,947. Correct?
Yes, Your Lordship.
174,62,947. Just multiply it by 18%. How much is it?
31 lakhs 43,300.
31 lakh.
Yes, Your Lordship.
So this is 1 year interest. So divided by 2 for 6 months, it comes to 16 lakh rupees almost. So this notice was issued in February.
Yes, Your Lordship.
Today we are in August. So this 16 lakh rupees interest has been added by now. MSME is 18%, right?
Yes, Your
18% it has been reduced. 18%. Correct.
Yes, Your Lordship.
So should we pass a order directing the respondents to tell us who is going to pay the interest? Which officer will be paying the interest?
Yes, Your Lordship.
Should we pass an order?
Yes, Your Lordship.
Otherwise, they will not give you any instructions. You send this order and then you will get instructions by tomorrow. You transmit it today, tomorrow they will giving it to you.
Yes, Your Lordship.
All sides are represented. Ms. Swanswell and a government advocate prays for some more time for filing an affidavit as she is yet to receive instructions. Next para. In this writ petition was filed on 19/2/2026 and the petitioner claims a sum of rupees 1,74,62,947 with statutory interest thereon under the MS and ME Development Act, 2006. Stop. In this case, notice was issued by order dated 27/2/2026. Stop. Next para. Therefore, comma, 6 months' time has already gone by, and in a rough estimate, the interest burden on the state for these 6 months would be more than rupees 15 lakh. Next para. Therefore, comma, in the event the respondents do not file their affidavit, comma, the Secretary to the Government of Mizoram, comma, Power and Electricity Department shall apprise this court as to which officer is in delay in not providing instructions to the government advocate, and as to whether and as to whether the state has any mechanism to realize interest on delay, the interest on the delay on part of the respondent officials to provide instructions and realize it from the concerned official who is found to have caused delay. Most of this information should be provided in case the affidavits by the concerned state respondents are not filed. Next paragraph, the learned government advocate shall transmit a rounded copy of this order to the respondent number 2 and 3, 2, 3 and 4 to bring this order to the notice of to their notice. Next paragraph, as prayed for, list on, give a date after 3 weeks.
The 8th of September.
When?
8th of September.
8th of September. Okay. Next.
Item number 4.
May I please, Your Lordship?
Yes.
In the last report, my Lord, service was deemed to be completed, but awaiting ID card from the respondent number 1, Your Lordship, District Collector. This is a petition, Your Lordship, which we are praying for a direction to the District Collector to do his statutory duty by hearing the petitioners and the respondents under Section 28A of Land Acquisition Act, Your Lordship. The statement will start from para 8, page 22, Your Lord. Page 19, Your Lordship.
You are projecting that this, after the Supreme Court judgment in this Adanya,
My Lord,
second application can be filed.
my Lord, my Lord, my Lord.
Yes, but then why no affidavits are being filed? Who is appearing
In
for
the
the
law-
character?
Nobody appears, my Lord. In the last order, ID card seems to be awaited from the respondent number 1, District Collector, my Lord. 1 month have passed, and I have already inquired that the District Collector has received the petitions. But with respect to Your Lordship, I don't believe ID card
Where
will
is-
be returned.
Have you annexed that order? Have you annexed the Supreme Court order here?
Yes, Your Lordship. That is in page 89, Your Lordship.
69.
89, 89, Your Lordship.
Even the NF Railway is not there.
If my lord is please, let an order be passed that on the next date, if they don't appear, this honorable court may pass appropriate order, my lord.
No, we'll see that this is taken care of.
All right, my lord.
Please record his name, Learned Counsel's name. Have the Learned Counsel's name recorded. Heard so-and-so, Learned Counsel for the petitioners. There is no representation from the government advocate for the state as well as the learned CGC or the learned departmental counsel for the NF Railway, who are by the state. Just a moment. State in respect of respondent number 1, the district collector, Kolasib district, or for respondent numbers, or CGC, or counsel for NF Railway for responses numbers 2 to 4. Next para. The default on part of the government advocates and the learned CGC or NF Railway advocate to appear is not at all appreciated. Next para. Accordingly, the registry shall transmit a downloaded copy of this order to the Chief Secretary to the Government of Mizoram to ensure that on the next date by the next date they would take a decision to ensure that the presence of the learned government advocates are ensured, to ensure that the government advocates appear in the court on all the cases which they are assigned to, or in default to revisit the list of government advocates in view of the default. Next para. Similarly, the registry shall send a downloaded copy of this order to the Ministry of Railways, Government of India, as well as to the Ministry of Law and Justice, to ensure that the learned CGC or the government advocates for the Central Government Council for the NF Railway is always present before the court when the matters are called, failing which they would revisit the list of CGC and government advocates to appear for the NF Railway, so as to ensure that the government advocates appear before the court on all the date fixed. Next para. In this case, the petitioners claim that they are entitled to enhanced compensation, which was earlier fixed at the rate of rupees 25 per square, 75 rupees per. What is the amount?
Enhanced amount was 68.
Rupees 25 per square feet, which is enhanced to rupees 68 per square feet, for which reliance is placed on the decision of the Supreme Court of India in the case of Supreme Court dated 1/12/2025, passed in Civil Appeal 1486/2025, arising out of SLP within bracket C number 11693/2024, give a dash, Rothanga, ROTHANGA and others versus Northeast Frontier Railway and another. Full stop. As the prayer made in this writ petition will have a big financial implication, comma, the absence of the learned government advocate and the learned CGs is not appreciated. Next para. For weeks time is granted from the date of the order to the respondents to file their affidavit. Full stop. List the matter on, give it date after 5 weeks.
Can it come up on September 14th, Tuesday, or 15th, Tuesday, September, Your Lordship? That is after 5 weeks.
If I may seek a Lordship's
Make
indulgence.
it weeks on 21st September. Yes.
If I may seek a Lordship's indulgence, my Lord, it's a usual practice that whenever a petition is filed, a copy is given to the government side, my Lord.
Yes.
Maybe in this case, we were not given a copy of the writ petition. That is why we have not appeared, my Lord. Perhaps we are on court every day, my Lord, the government advocates.
No, if it is not filed, you should have said, somebody should have appeared and told us. You don't allow us to pass orders and then say that copies were not served. Why no objection was raised when the matter was taken up?
Because before filing, my Lord, we are served a copy, the government copies are served,
see-
and our names are reflected, my Lord.
Please understand.
Yes, my Lord.
In this case, the notice has been given earlier. Then AD card has come back. The service has been made to respondents of 4 to 6. Yes, why you have not given the copies?
Yes,
You-
usually as a practice, particularly if the respondent is the district collector, they used to engage a separate counsel, my lord.
No. Whether they engage or not, that is not your lookout. He is a government servant and therefore he will have to serve notice to the government. We don't know what practice is going on here. He is a government servant and he is the specified authority to take up the land acquisition matters. No, whether you send notices or not, but it's duty bound to give copies. We'll take it up at 2 o'clock. In the meantime, I'll speak to the registrars to the practice going on here.
Yes, my Lord.
Be here at 2 o'clock
Obliged.
My-
because this practice must be made.
Item number 5.
My Lord, as per the last order, my Lord, I was to file my rejoinder affidavit against the affidavit filed by the respondent 2 to 5. And my Lord, the reason I could not file is that I had sought for an information, a specific information regarding the NH 54. So that information is with me, and my Lord, hopefully within 3 weeks I can file the affidavit. The information, my Lord, specifically states that there was an assessment of the assets, specifically stone quarries within the national.
Which page is that impugn order? 3821.
3821. Annexure 8, page 112.
How you are interested in this land? This is not your land.
My lord,
You have been given a mining query, right?
correct, my lord.
This query expired in 2022. You have no right to be there. How you are affected by this acquisition order at 120? Which page was that impugned order?
The impugned order is 112, my lord.
112.
Yes.
How you can be aggrieved by this?
My lord, so when the assessment notification and the 3A was published, my lord. there was
Correct, but you are not the
complete
owner of the land. You just had a mining lease.
My lord, we own the land, my lord. I own the land. The taxes were paid and the,
Where is that statement that you own the land?
my lord.
In the state of Mizoram, the sale and purchase has to be compulsory registered. There is no exemption from the Registration Act.
Correct, my lord.
Is it? Is there a exemption?
No, my lord.
Registration Act is not exempted. Then under section 49, we can't even read a document which is not, for which sale of the land has affected and is not been registered. Section 49 creates a bar. So this writ petition would not be maintainable at your instance.
My lord, kindly allow me 3 weeks to file my rejoinder affidavit in this matter. So
Pardon me?
kindly allow me 3 weeks to file my rejoinder.
But it is not even maintainable. How would it affect whether you file an affidavit or not? On the basis of your statement made in the writ petition only, this writ petition is not maintainable.
My lord, this honorable court had passed an order in WPC 106 of 21, wherein the
Page?
Page 136. It's in part of the annexes, my lord. 136. Wherein this honorable court had held that the petitioners are entitled to the assessment made in the assets, specifically that of stone quarries. And in that case, my lord, the Kala had taken the sense that the same cannot be affected. The assessment cannot be affected due to this specific order.
You see, from this order, at this page 136, which you are referring to, it does not refer to any acquiring of the ownership of the land by way of an unregistered sale deed. Please correct me if it's so, because I flip papers, I don't read it so thoroughly. So this order proceeds on the premises that the writ petition 106 of 2021, that petitioners are the owners of the land. In your petition is structured on two pillars. First is that you are not the owner, you had purchased the land, it is not registered, but the village council took notice of that.
Correct.
So village council is no authority when Registration Act is in force. For section 49, as I said, creates a bar. For a document registrable under 17C to be taken note of. So therefore, there is a bar. And second is, your second structure is, second pillar of your writ petition is that you were given the permit for mining. That mining period lease itself shows that it expires in 2022. So it's a simple theory. If the pillars fall, the structure falls.
So, being in possession of the mining permit, my lord, our basic contention is that we are entitled as much as we own the specific land. And my lord, recently the Kerala High Court had quashed the constitutional validity of the act, wherein the state government had absorbed the rights of the minerals and.
But still, you don't get the benefit. That the decision of Kerala High Court depends on Article 254. It says that when there is a new act which has come and is covered by the concurrent list, then there is an implied repeal of the state act. So that even our High Court, in a bench, in an order which is authored by me, we have made that averment. The Kerala High Court judgment came thereafter. So whatever is beneficial, that will prevail. So therefore, the 2013 Act will prevail. That is the ratio in this Kerala judgment. You are aware of it. But if you don't have a right, how will that Kerala judgment apply?
So, as I have prayed initially, my lord, kindly allow me 3 weeks, my lord. And if the state government raises an objection as to maintainability, then.
To say all sides are represented. In this repetition, one of the statements made by the petitioners is to the effect that they are the owner of land on the basis of sale of land by the previous owners, of which the village council took notice. No, which was acknowledged by the village council. Full stop. Second plea in the writ petition is that they have been enjoying a mining lease issued by the state government, by the appropriate government. Full stop. In this regard, the court query is to the effect that how can the High Court take cognizance of unregistered sale of a land valued at more than rupees 100 in view of bar created under section 49 of the Registration Act. Just give that act, Registration Act. Registration Act. To receive any document as evidence of any transaction affecting such property or conferring such power if the document is not registered. Full stop. In respect of the second point, comma, as per the documents annexed in the writ petition, comma, the mining permit purportedly issued to the petitioner had expired during the period 30/4/2021 due to 31/3/2022. Next para. Be that as it may, to respond to the court query in order to file an affidavit by the petitioner, the learned counsel for the petitioner prays for adjournment. Next prayer is allowed. List after
3 weeks, my lord.
3 weeks.
Your Lordship, I am appearing on behalf of the state respondents 4 and 5. Your Lordship, we are yet to file affidavit of opposition. We'll be filing it by next week, if I may be allowed to file the same by next week.
On the prayer made by government advocate for respondent 3 to 5.
Your Lordship, 4 and 5.
Okay, 4 and 5. 3 weeks time is granted to file affidavit in opposition in the matter.
Much obliged, Your Lordship.
I'm obliged.
Item number 6.
My lord, I am for all the respondent. As per the last order, I was directed to obtain instruction. Accordingly, my lord, I received instruction wherein they stated that the petitioner have to submit 4 documents to the respondent, and the person may be further necessary step may be taken. Then, however, my lord, if I may permitted to submit my instruction, or I may be permitted to file by way of additional affidavit.
Pass it on. Give a copy to him. We'll
Yes.
put in the order. Just give this copy, photocopy to him so that he can get it. Heard she so-and-so, learned counsel for the petitioner. Also heard Ms. So-and-so, learned CGC appearing for the
All the respondent.
respondents. Next para. Pursuant to order dated 7/5/2026, the learned CGC has produced a copy of written instructions dated 23/6/2026. Requiring furnishing of updated documents by the petitioner to entitle her to family pension, so, accompanied with the said instructions are letters dated 16/1/2026 and 10/3/2026. Next para. The copy of instructions is perused and returned, to be produced on the next date of listing. Next para. The learned CGC shall provide a photocopy of the said instructions dated 23/6/2026 and the copies of enclosures dated 16/1/2026 and 10/3/2026 to the learned counsel for the petitioner, so as to enable the petitioner to submit documents to the competent authorities. Next para. It is made clear that the pendency of this writ petition shall not be a bar for the petitioner to submit further documents as required, and if the documents are in order, comma, it would be open to the respondent authorities to release the family pension to the petitioner. Next para. While sending the documents, comma, the petitioner shall also send a certified copy of the orders so as to enable the authorities to examine and pass appropriate orders in the application filed by the petitioner for family pension. List on, give a date after 4 weeks. We are permitting you to file documents along with copy of the order, and the respondents can process and pay.
10th of September.
Oblige, Your Lordship.
Oblige.
Item 7.
Yes. What is your stand regarding the DPC?
My Lord, in this, the stand of the government is that the petitioner was recruited as a Group D employee, peon, my Lord, not as a driver. But the petitioner presently are claiming the pay scale of a driver, that is a Group C post, my Lord.
Okay.
Yes, Lord.
And according to you, where is the appointment orders?
My Lord, his duty as a driver, my Lord, at Annexure 1 of the affidavit in opposition of the state, my Lord. Page 24, my Lord. Office order dated 21st April 2011, my Lord.
Okay. And for grade 4, what is the promotional avenues? Grade 4 will also get promoted by
Yes,
flux of time.
Group D, my Lord.
Can you help me to read it? Page 39 is your annexure of recruitment regulation for group B, C, and D.
Yes, my Lord.
Now, driver comes at serial number 7. Now, what is the...
Group C, non-gazetted.
This is group C.
Yes, my Lord.
Okay, so he is appointed in group D and then made to work as group C.
Yes, my Lord. If we look at the order that was I suggested, my Lord, at page 24.
We have seen that.
This is the office order that has detailed him to...
But then,
Yes, my Lord.
a driver in grade C, a peon in grade D is entitled to be promoted.
Yes.
What would be the nature of exercise?
My Lord, he was recruited as a peon, not a driver.
No, we understand.
Yes,
But even a peon would be entitled to be considered for promotion.
Yes, my lord.
So even for that, okay, none appears on call for the petitioner. How is she concerned? Learned. Your designation is
Additional Advocate General.
Additional Advocate General. For the respondent numbers 1 to 5 is present. Next para. The learned Additional Advocate General has submitted that as per Annexure 1 to the affidavit in opposition, comma, though the petitioner was engaged as a peon, comma, which is a Group D post, comma, the authorities had allowed him to had utilized his service as a Roman 4 grade dash cum dash driver till further orders. So accordingly, it is submitted that as driver is a Group C post, comma, to which the petitioner was not appointed, comma, he would not be entitled to claim his promotion in terms of the prayer made in the writ petition. Next para. Be that as it may, as the petitioner claims to have been appointed in the year 2011 in the post of peon, which according to the learned Additional Advocate General is a Group D post, comma, he will apprise the court as to the provision in the relevant service rules which entitle the a Group D appointee to be considered for promotion to the next higher grade. Next para. Next for the learned Additional Advocate General shall apprise the court on the next date of listing. Next para list on after 2 weeks.
2 weeks, ma'am.
Should I say that if he is otherwise entitled to be considered for promotion, suitable DPC should be constituted?
My lord, as of now, we are our submission is that, my lord, since he was engaged as a peon, my lord.
No, we are not asking you to consider him for promotion from grade C to.
Let me first
upward.
produce the.
If he is entitled to be considered for promotion to from grade D to grade C,
Yes, ma'am.
then that exercise should go on even without the order of the court.
Let me just produce the promotional avenue for grade D first, my lord, as per your lordship's order. Then we'll see, my lord.
Unless there is a delay, if there is 15 years a person is a peon,
Yes, ma'am.
I think he becomes entitled to promotion,
Yes.
to be considered for promotion.
Let me produce it first, ma'am.
Okay.
Like,
I'll take a break and come back. Give me 5 minutes.
Item number 9.
Okay. You are for
Please, Your
the
Lordship.
appellant?
Yes, your
Okay.
yes, Your
Heard
Lordship.
Ms. So-and-so done counsel for the appellant. Next para, issue notice on this. Appeal filed under section 17 within bracket 2 of the Mizoram Civil Courts Act, comma 2005, read with section 96 and order 41 of the CPC against the judgment and order dated 25/6/2026, comma passed by the learned civil judge, comma senior division -3, comma Aizol, comma thereby dismissing the suit. Sorry. Just a moment. This against the judgment and order dated so and so passed by the learned civil judge so and so in civil suit number 79 of 2024, comma, which was dismissed. Next paragraph. The appellant shall take steps within 2 working days for service of notice on the respondents by speed post with AD. Next paragraph. The learned counsel for the appellant is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing.
Your Lordship, please, can I explain a few points? I made corrigendum on 11/6/2025, the address of defendant number 1. It never come out in the order, or they never changed the defendant number 1, the address. Can you change for notice issuance?
Please repeat again.
Your Lordship, on 16 July 2024, my first applications was in the name of civil suit number 79 of 2024. And after I received a written statement, I
We issued notice. We have issued notice. You want us to hear the appeal without
they
notice?
keep on denying, Your Honor, Your Lordship. They keep on denying the address, Your Lordship.
Pardon me? Please repeat
The
again.
Respondent number 1, they keep on denying the address. And I made corrigendum dated 11/6/2025. While sending the notice, can you please change the, or like,
I couldn't understand. Please repeat again.
Your Lordship, the order,
Your suit was dismissed.
yes,
Yes.
respondent number 1, 3, and respondent number 1, 4, and 5 never present in the lower court.
So,
Through their written statement I received in the lower court, the address of the respondent number 1 need some alteration. And I made corrigendum on the lower court, but that amendment never come up in picture.
which page is your petition?
Your Lordship, page number 32.
32.
Yes, Your Lordship.
Reading this page 32 onwards, I have not understood what do you want to say in your plaint. What is your case?
Your Lordship, I have bought a car. I have bought a car on 23rd April 2024. Then some unknown people had tried to collect my car. And as per their definitions, their office were somewhere else, and I could not detect because I was never a loanee to that institution, and I never
But
applied for the protection.
why this simple thing you cannot write simply? I've read it twice. I couldn't understand anything.
The respondent tried to make
You-
me.
Where is your statement that you have bought a car? From whom you have bought a car? Who is
They had delivered in my home on
Who has
23rd
delivered?
April 2024.
who has delivered?
Respondent number 4 and 5.
Where is the document of registration of the vehicle?
Registrations of vehicle was annexed on written statement by defendant number 2 and 3. They have brought the car along license in my doorstep. Page number 56.
I don't know. Nothing material is there in your plaint. We don't find the registration certificate of the vehicle. Which page is it? It is. Then secondly, nothing in this plaint is understood. If you have bought a property, first thing is that you say that you have purchased the property from the vendor who is the registered owner. That you don't say. Then you give a statement which perhaps I'll take a day to understand in the plaint as to what you actually intend to say. then you say that you are pressurized, given undue pressure, but for what you have not said. What is your liability against that car? You have not said. What is the initial payment you made, and what is the due? You have not said. You have not referred to the agreement in your plaint by virtue of which you agree to purchase a car. Secondly, the sale letter says that the sale was made by second-hand dealer. How the second-hand dealer got the right to sell, we don't know. Fourthly, in this sale letter, he says that if there is any claim with regard to the loan, he is not responsible. And then you have made this Chola Finance a party. How they are responsible? You have not said anything. You said that he is an agent. That claim of agency, against the claim of agency, you are relying on a second-hand car dealer certificate. Then what is the liability of that financer?
Your Lordship, it was wrong it was wrong for me to lose like 3 lakh within a couple of months, 1 month, 2 months.
But what is, you see, your statement, you have seen Kaun Banega Crorepati? Phone a friend. Now there are a lot of friends sitting behind. Let anyone read this and then tell me what do you intend? And secondly, you file a petition for amendment. You must know how to file a prayer for amendment. You have to make a prayer only and give the schedule of what you are trying to amend. And in your amendment petition itself is a plaint. What is the fact you want to amend? You have not said.
The address of respondent number 1.
That is not how a amendment application is presented. In the High Court, how will you do it? If you want to amend the cost title, what do you say? You give a first cost title saying that this is the cost title, then inside you say that the cost title of respect of A is replaced by this. It must be there in the schedule. And then you make a prayer that please amend the cost title. That's everything you have to say. And when you're filing a civil suit, you don't read the CPC. CPC said that if address is required to be changed, you just have to file a memo of registered address of parties. You don't have to amend a plaint for the purpose of changing the address.
It was a directions from the lower court, Your Lordship.
No, but where is the order to that effect? You must press this application. Some order would have been passed. You have not produced. We have seen the documents annexed. You have not annexed any single document where you have shown this application to have been filed and considered. This was filed on 11/6/25. Correct? You come to page 76. Your order sheet is there up to 6/5/2026. So 11/6/2026 order sheet you don't annex. How would we know what is happening in the trial court when you don't produce the documents? And you know why this application was never considered? Can you gather? Now you are holding the brief. Have you gathered why this petition was never considered by the trial court? Answer is at page 76. Page 76 says that the learned counsel for the parties are present. Today is for hearing. Heard the learned counsel, fixed so and so for necessary orders. Now, madam, please be assured, if I hear this matter today and make it CAV, no other interrogatory applications will be considered when the matter is kept as CAV. No matter whatsoever you file, it will never come to my record. If I am the presiding officer in this court, and if I have heard a matter, made it CAV, no matter whatever you file after the record is made CAV, it will never come to my record. Nobody in the registry can come to my chamber and then annex or keep something in the record after it has been made CAV. It is exclusively within the domain of the judge. So your application for amendment, whatever we don't find it is an amendment application, it will never be brought to record. Because this application was filed after the matter was heard.
To help the matter, Your Lordship, page number 74. No documents who, if those persons, the respondent who filed their statement, they don't have any evidence or record to produce.
Not required. Have you never seen a ex parte suit being dismissed? A writ petition where nobody has appeared, can't we dismiss it? There is no provision in the CPC for rejection of a first appeal in limine. But we can still exercise that power. We must understand what is there in the plaint. And in the plaint, you have not said anything which can be understood. If you are purchasing a property, let us forget about the car. Any property you purchase, let us say you go to a mall and purchase a shirt or a trouser, and then it is defective, you file a complaint under the Consumer Protection Act. How will you present the plaint? You will say on so and so I went to that shop, purchased this pant or this garment, it is defective. This is the memo of purchase. This is the defect. We ask them to rectify the defect not done and therefore case for compensation. The storyline made in your plaint doesn't make any intelligible understanding.
My plaint has said
You
that
must understand that claim. You are wanting an order from us. I must understand at least one paragraph of anything in the plaint.
Your Lordship, it was a matter of
You understand? Please read the plaint. Read and make us understand even one paragraph of this plaint. Plaintiff is a bona fide citizen belonging to Mizo community, para 1. Para 2, defendants are also citizen of India belonging to so and so in Aizawl. 3, defendant number 1 is a finance company and it's alike calling themselves loan agency in Aizawl. Para 4, the defendant number 2 plays active role who is first informed the plaintiff of all unexpected liabilities and claiming himself to be institution without offset, write off, pay of detail, periodic statement and periodic rate demand and the plaintiff to return the said car to pay further money to him. What do you understand of this language? Para 5. The defendant number 3 act as owner by posting the figure of plaintiff along with the car at Facebook. Supposing tomorrow when I go to Aizawl airport, have my photograph taken in front of the aircraft, I become the owner by posting it in the Facebook. There's a lovely way to do it. Para 6. Defendant number 4 has actively been used as a trade tool and even demand 145,000 so as to release the said vehicle. If you have purchased the vehicle, what is the question of release of the vehicle? Para 7. Defendant number 5 carries original documents and transfer the car at her direction with the plaintiff while believing to be fully discharged or due. Rendered rupees 3 lakh. That means you have not even got the vehicle, the documents of the vehicle. Para 8. Plaintiff thereafter, without being unaware of scam, undue influence, willfully accept all the original documents along with the vehicle. And then when we ask you where is the document of registration, you say that the defendant has filed it. If you have the original documents, why don't you annex those in your plaint? Defendant number 5, after a week of receiving money, visited the plaintiff. Now defendant number 3 shows herself to be the owner, you pay to defendant number 5. Plaintiff had received a call from the agent of defendant number 1, who is defendant number 2, and demand the plaintiff to return. If you have purchased a car from 3, make payment to 5. How 2 is demanding it? You have said nothing.
Your Lordship, order point number 3 has said that I had bought the vehicle through Facebook post,
But when I'm reading it, can you understand anything?
yes,
You can.
yes.
Then you are more intelligent than us. We certify that.
Your Lordship, in future, many will become fall prey of this. If reasonable result has not been given in this application.
If it is fraud, you file a complaint petition, you file a civil suit. In civil suit, it is your responsibility to prove it. Para 11, the plaintiff under such degree of pressure and mental abnormality in the state of confusion planned to keep with the said car with him. That means you are keeping a car with the defendant, which defendant we don't know, but you want to keep the car with him. That's not extortion and taking away the vehicle from your ownership. It's not parting with possession. You say that you want to keep the car with him. Though their presumed agent, defendant number 2, mentioned all unexpected burden, which is difficult for the plaintiff who failed to understand all the terminology of consideration of that company carries with them. What do you mean by this? We don't know. We go by your word that you have understood. But we have not. The para 12, the plaintiff has even sent rupees 28,000 on 6/6/24 upon the company who claimed to be their agent, that it is put as defendant number 4. So that means now you pay to defendant number 1. And the plaintiff with low education, without knowing the difference between bid, auction, blindly trusts the presumed company agent. That means now you are saying that you know that it was a car vehicle which was sold in auction. Unfortunately, defendant 1, the presumed agent, never sent returned receipt, which create fear in the mind of the plaintiff. That means you purchased the vehicle and the money receipt is not there. that the defendant are residing in Aizawl and Kolasib, Mizoram. The cause of action also arises with Aizawl, where the car must be kept in safe custody, where bailment procedure was first let loose by undue influence, which is within the jurisdiction of this court. I really need some time to understand. Unfortunately, your understanding will not allow us to pass an order, because we must understand when we are passing the order, we will take the responsibility of the orders.
Your Lordship, page number 50, if the defendant number 5 had bought from the final institution, there is no recourse of her buying those things. Written statement, page number 50. If the defendant,
You forget the written statement. If you
Page
don't
number
understand the
50.
plaint,
page number 50. Written statement by respondent number 2 and 3.
give us this. Order 41 to 11. So even without issuance of notice and calling for the records, we can dismiss the appeal in limine. And you see, your prayer in the plaint is A. Pass a decree in favor of the plaintiff and against the defendants. So, what sort of decree you don't say? B. Pass a decree directing defendant number 1 to pay to the plaintiff the outstanding due amount of rupees 3,28,000. How you, after purchasing the car, 3,28,000 is due to you?
Your Lordship, for
As a-
for finality of the car, without any burden, future burden, I pay to
You
them.
look at the prayer. We are reading out the prayer and asking you what does it mean. Pass a decree directing defendant number 1 to pay to the plaintiff the outstanding due amount of rupees 3,28,000 with interest of 5% per annum, who fails to maintain the car in safe custody and use it as a weapon of Ponzi. What sort of prayer is this?
It was the amount received by defendant number 5.
That you have not said. You said amounting outstanding due. Outstanding dues, if you are purchasing the car, the money will be payable by you. Or somebody gives a vehicle along with money. That you purchase my vehicle, I will give you 3,28,000.
respondent number 2 and 3 try to make me pay further.
You look at your player, defendant number 1. Where is your contract with defendant number 1 to make them pay?
Yes, I had never made a contract with defendant number 1 because I have never making applications to be a
That is
lawyer.
why you should have been happy when we should notice without looking at anything. You made us read that. And then you are now in a spot. You say that you have purchased it from defendant number 3 whose photograph was there with the car. And now you are wanting a decree of 3,28,000 from defendant number 1.
Because they were the main reasons who forged the calamity.
When you draft a plaint, you must have a plan in mind. Even movies which are otherwise, if you think without looking at after looking at the movie, you may think one movie to be very absurd. For example, Mission Impossible. But at least they have a storyline.
Your Lordship, I want you, that's all.
They can make you sit at a place for 2 hours with some storyline, whether it is absurd or not.
Your Lordship, if justice is served, then no one will become a prey of. In future, no one will become a prey of those.
First, you make us understand what you have understood. Pass a decree directing defendant number 2 to pay 50,000 as mental harassment and to pay further rupees 3,28,000 he claimed to be the role player.
Your Lordship, if defendant number 5 happily received 3 lakh and...
You see, in the entire plaint we have read, you have not even said that we entered into a contract with a particular person to purchase a car at so and so rupees.
Yes.
That basic statement is not there. What is the agreed value? You don't say.
It was...
Pay a decree of defendant number 3 to pay rupees 5 lakh as cyber defamation. Now, in the entire plaint, where is the reference to a defamation? Then you say, pass a decree directing the defendants to pay 20,000 as court fee. And your statement in earlier paragraph is that you are entitled to pay court fee of 5,000 since you are a taxpayer in Mizoram. House taxpayer, therefore your court fee is 5,000. And you claim a decree of 20,000. Pass an order to attach the money public bill received by the defendant and keep in safe custody. What bill? Sorry, this is a appeal which has to be dismissed in limine. This is not how plaint should be presented. Your amendment application is again the plaint, replica of the plaint, and it is more confusing than the plaint itself. You want to know why your amendment application is more confusing than the original plaint? Come to page 34. In the cost title, you write a suit under section 7 of the Negotiable Instruments Act 1881, and to stop directing the plaintiff, who is neither the payee nor assignee of assets upon the Chola Finance, which is a mandate to mention valid instrument, that is total rupees 8,48,000. How do you arrive at this? We don't know. And what is a suit under Section 7 of the Negotiable Instruments Act?
Because he was never an assignee because he never take his documents like Aadhaar card, bank statement to the finance institution.
So if he's
Although
not the
they
assignee, if he's not the assignee, then you can file a suit under Section 7 of the Negotiable Instruments Act. Give me Negotiable Instruments Act. Section 7 of the Negotiable Instruments Act is a definition clause. Says drawer and drawee, drawee in case of need, acceptor for honor, payee.
Yes.
How can a suit be framed under Section 7 of the Negotiable Instruments Act? In your entire blend, there is no drawer, no drawee, no instrument of under the Negotiable Instruments Act, no check, no bill of lading, no negotiable instrument.
Your Lordship, I am a driver illiterate and I did not know on the time of buying the vehicles, I did not know that I need to apply for applications and all. And they just
It's a must that you have to have at least a registration certificate. In your plaint, you say that and then you deny it. And that's why we asked the first question we asked was that where is the document? You said the defendant filed it. How can the plaintiff not file a document and succeed in a suit? Sorry, we'll be dismissing your appeal in limine. It's not a case to issue a notice. And where is the ingredients of a cyber defamation?
page number 42, my picture was posted.
42.
43. My picture was posted along defendant number 5. And the lower court judgment has said that I have bought the vehicle through that advertisement. While my picture was there, and there was misinterpretations. I was in urgent need of that vehicles only to take my sick wife for medical treatment and visiting hospitals.
Don't even say what is the date of this post.
For a couple of weeks, we the family cannot even take a good sleep because
But
they
when is
just-
that? When was this post made?
I was not an user of Facebook and I did not know it was a reshared, screenshot was reshared to me on first week of June 2024.
These things are not stated anywhere. You're a good lawyer, you can cook up a story very fast. But unfortunately, they're not there in the plaint. She's also learned counsel for the appellate. This appeal has been filed under section 17 within bracket 2 of the Mizoram Civil Courts Act. This is cost title page 1. Under so and so. Order dated so and so, passed by the civil judge, senior division, -3, numerical 3, Aizawl, district, Mizoram, in civil suit number 79 of 2024. Next paragraph. By the impugned judgment and decree, the suit filed by the petitioner appellant was dismissed. Next paragraph. On a perusal of the plaint, the case of the petitioner could not be easily understood. Accordingly, the learned counsel for the petitioner was asked to explain the case of the appellant. Next paragraph. The case of the appellant, as submitted by the learned counsel for the appellant, is that she had been sold a car by the respondent numbers 4 to 5, 4 and 5. First, it is submitted that the car was delivered at a doorstep of the appellant's doorstep. And as per the averments made in the plaint, part of sum of rupees $95,000 was sum of rupees 95,000 was paid by GPay on 23/4/2024, and a sum of rupees 2,05,000 was paid in cash. Stop. It is not discernible from the plaint as to which of the defendant was paid the said amount. First of all, the case of the petitioner, the appellant. The case of the appellant is that the appellant received a call from the defendant number 2, who claiming as agent of defendant number 1, so defendant respective respondent number 1 had demanded that the plaintiff, that the appellant return the said car to his office. Full stop. From the plaint, it is not clear as to whether the appellant returned the said vehicle or it was seized or she had parted with possession of the said vehicle. Full stop. However, it can be gathered from the statement made in paragraph 11 of the plaint that the appellant planned to keep the said car with the respondent number 2 full stop. Accordingly, the appellant, by filing the suit, made the following prayers. Page 21 to page 22, A, B, C, D, E, F, G. Next paragraph. On a perusal of the documents appended to the written statement. It is made to appear that the said vehicle was the previous owner of the said vehicle was one Lalram, Lalram, Nghaka. In whose name the statement account has been generated by the by the respondent number 1. However, as per the statement made in paragraph 12.1 of the written statement filed by the respondent numbers 2 and 3, the respondent number 5, namely Lalduatmai, Lalduatmai, within bracket, respondent number 5 who had bought the said vehicle by taking finance from the respondent number 1, and the said vehicle appears to have been sold to the appellant even before the existing loan was paid. Stop. From the documents annexed with the written statement, it appears that in the sale letter purportedly issued by the respondent number 5, it was stated that on 23/4/2024, Tuesday, his vehicle Ignis, IGNIS, was sold to the appellants with a promise that if there is any problem regarding loan or other problems, the appellant will not take any responsibilities. We'll continue to Charge sheet is submitted where? Special
Yes,
court?
it is captured value.
To the email to the London to the London Judge,
18/4,
special
2020.
court
Next month.
within bracket ND and PS bracket close eyes on. It will be permissible for the said London court to send the scanned copy of the records through email for being placed before the court. Next para. Let the order be brought to the notice of AO within bracket J. Next para, list on 18/8/2026.
My lord.
Obliged.
Deeply obliged.
Supplementary list, item number 13.
Your Lordship, this is regular second appeal.
Yes.
The appeal has been preferred from the judgment and order dated 1/4/2026. Lordship, a certified copy of the judgment in RFA number 11 of 2021 been the front page of the memorandum of appeal. Lordship, this being second appeal, the appellants have proposed the
You are the plaintiff or the defendant?
I am the defendant number 1 and 2.
You are the defendant number 1. Defendant 1 plus defendant 2. Yes.
And we had first, we had earlier approached this, the Lanet lower appellate courts by filing RFA number 11 of 2021, copy of which is at page 116 to 148.
Which page is the order of the London trial court?
Trial court judgment in order is at page 71. The judgment and order was dated 18/10/2021. Suit was decreed in favor of the plaintiff. The decree is at page 113. That's it.
As defendant number 1 and 2, how do you assert your right and claim over the suit land?
Your Lordship, we have made a counterclaim. We were issued the land settlement certificates (529 of 2010) 509 of 2010.
What was the basis of that land settlement certificate?
Lordship, at the time of cadastral survey, we were in possession and occupying the suit land for a number of years, more than 30 years now. And Lordship, Pazona, who is the brother of the deceased Lalngena, he was the one who looked after Lalngena till his death. And Pazona died on 9/5/2011.
Just a moment. The owner of the land is
Owner of the land is Lalngena,
how do you spell it?
Lalngena, Lalngena.
Yes.
After the death of Lalngena, the land was under occupation of the appellant number one, Pazona. And after his death, he was substituted by Vandal Tantra.
Just a moment. Since I am not very acquainted with the names, I am just asking you again. The owner is Lalangena. After this, the land was mutated in the name of?
It was mutated in the name of Vandal Moya. It was mutated in the name of Vandal Moya. It is a periodic pata.
That is a plaintiff.
Hello, sir.
This the mutation was done in the name of?
In the name of Vandal Moya, the
Vandal Moya is the
plaintiff.
Ah. Yes.
And Lalngena
what is the relation between this Lalanga and this Valmangia?
Lalngena is the
son.
Lalngena is the elder brother of the father, the late father of the plaintiff.
Elder brother of father of the plaintiff.
Elder brother of the father of the plaintiff.
Yes.
And the prior to issuance of P Pata number 377 of 1978, which was issued in the name of Lalngena, he was earlier issued permit number 66 of 1961.
The land is covered by Patta number 377.
377 of 1978.
Of 1978.
Yes. It was issued for a period of 5 years. Periodic Pata is for a particular period.
5-year period.
5 years.
Okay.
And which was issued on 5/10/1978.
Five 1978.
Yes.
Yes.
If I take a lordship to the Roman number 3, the list of dates and events, lordship will see it here.
Yes.
So this is the date when permit the PPTA number 377 of 1978 was issued. And in the meantime, during the validity period of the said PPTA,
Please tell me in your list of dates, the first is permit number 66.
Yes.
What is the difference between permit and the
Permit is, it's a temporary permission of the allottee to cultivate and to look after for a particular period, for a particular purpose.
Okay.
And thereafter, that permit number 66 of 1961, which was issued to Lalngena on 1/6/1961, was superseded by this PPTA number 377 of 1978.
Yes.
And the allottee, that is Lalngena, the original owner of the suit land, he expired on 15/4/1980.
Yes.
And the expiry of the PPTA number 377 of 1978, after the life of the PPTA, that is for 5 years, was on 31/12/1983. 31/12/1983, the PPTA had expired. It was not renewed for a number of years. It remained under occupation of the appellant number 1 and 2. In spite of the fact that the said PPTA was not renewed, it was under occupation of the appellants number 1 and 2 ever since the death of Lalngena. In fact, Lalngena was looked after and maintained by the appellant number 1 till his death. And without the knowledge and permission of the appellant number 1, the plaintiff, who is the respondent number 1, claiming himself to be the owner and the one who is to inherit over the land of the deceased, Lalngena, he had taken the said PPTA and got it renewed on 17/6/2002. 17/6/2002. Without disclosing that Lalngena had already died, and showing that he was acting on behalf of Lalngena. And thereafter, after its renewal, which was processed by the Revenue Department without making necessary inquiry as to whether Lalngena was still alive, after a long span of in between 1980 to 2002. The respondent number 1, who is the plaintiff, had presented an application in the name of Lalngena. And again, on 27/6/2002, he had submitted a document which is known as Muninpek na Lekha. That is supposed to be a gift deed. If I take a lordship to the gift deed,
So gift deed, who got the land?
gift deed is at page 55, a lordship.
The plaintiff got the land.
The plaintiff,
By gift
yes,
deed?
Yes. On the basis of this gift deed, the plaintiff was supposed to be the inheritor of the said land, that is LSC number 377 of 1978. The gift deed at page 55, Lordship. The English translation is at page 56.
Yes.
May I read the Lordship? The gift deed. This is a pro forma. It's a form, in fact, which is in use at that point of time for the purpose of transferring ownership of land from the original owner to the transferee. It says, on this day, dated 27 June 2002, I gifted my land or garden, LSC number 377, to my son, daughter, son, mother, father, grandmother, grandfather, etc. Friend, Vanal Moya. Vanal Moya is the plaintiff, son of daughter of Langena, and the reason is I want him to inherit my property. So there is a signature which is illegible, but this is the signature. It has to be the signature of the owner, but since Langena had already died in 1980, he could not have executed this particular gift deed in 2002. And on the basis of this fabricated document, and on the basis of this, the signature having been forced by the plaintiff, he had obtained the transfer of the ownership of the said Pipata, the suit land, in his name. Lordship, there was no issue. There was no issue at that point of time. In 2002, there was no issue because the defendants, number 1 and 2, did not know of any such transfer. And Lordship, in the year 2010, when the cadastral survey team under the revenue department, they went to the spot, trying to cover the entire village area for purpose of cadastral survey map. They approached the defendants, number 1 and 2, who were in occupation of the suit land, part of the suit land. It is a Pipata covering quite a big area. And since they were in occupation of the suit land, 2 LSCs, such as 529 of 2010 and 509 of 2010 were issued to the defendants number 1 and 2, who are the appellants number 1 and 2. Sri Pazona had since died. He had died. Sri Pazona had died on 9/5/2011. 9/5/2011. Has been substituted by the present appellant, Vanal Thanpuya, who has been appointed by him to be his legal heir on the basis of his will. Your Lordship, soon after the death of Sri Pazona on 9/5/2011, the plaintiff had approached the Court of Civil Judge 2, District Court, Aizawl, as can be seen at page 44, Your Lordship. At page 44, Your Lordship will see the heirship certificate, number 69 of 2011. May I read, Your Lordship?
Yes, we have read it.
Right. Lordship, this is a clear indication that the plaintiff had sought for being appointed as the legal heir of the defendant number 1. That is, the appellant number 1, who had died. It says, whereas Pazona, son of Hausik of Mualungpu, died on 9/5/2011, his nephew, Vanalmoy of Mualpui Police Complex, is hereby declared as legal heir of deceased Pazona in respect of so-and-so. Thereafter, Your Lordship, the plaintiff had come over to the spot. Otherwise, he was never there in the place.
No, just a moment. This page 44 document you are showing,
Yes, Your Lordship.
this is heirship certificate in respect of
In respect of
Pazana,
yes, LSC number.
PSADWNA,
Yes, Pazona.
and his nephew, that is the plaintiff,
Yes,
was declared legal heir.
yes.
Okay.
So since this heirship was applied and given without any notice, Your Lordship, a review was filed. On the subsequent page, Your Lordship will see the order passed by the Honorable Court on 6/9/2011. There is another order that was passed in connection with review application number 8 of 2011, rising out of heirship case number 69 of 2011. Has the Lordship, sorry?
Yes.
May I read the Lordship?
Yes.
This is an application for review of the order passed in heirship certificate number so-and-so, issued in favor of Vanal Moya, son of Lalngena, late, Mualpui Police Complex. He is not the son of Lalngena, he is a nephew of Lalngena. Anyway, he has shown himself as son of Lalngena only for the purpose of heirship. Mualpui Police Complex, Aizawl, by this court's order, White Memo number so-and-so, under the spirit of Order 47, read with section 114 and 151 CPC, and the application is submitted by Vanal Thanpuya, son of K. Laltlantangi, resident of Mual Lungtu Aizawl district, against Wanal Moya, son of Lalngena, Walpi Police Complex. Applicant is present through his learned counsel, W. Sam Joseph, and the OP is present through his learned counsel, Mr. R.K. Malsong Kim Advocate. Hearing is conducted today. This court is of the opinion that it is not appropriate to settle the emerging issues in an
This
application. for
review was filed by whom?
This review was filed by
Defendant
the
number 1.
defendant number 1.
Okay.
This court is of the opinion that it is not appropriate to settle the emerging issues in an application for issuance of certificate only. And after hearing both the counsels, it is decided that the review application be partly allowed and the airship certificate number 69 of 2011, white so and so, dated 3/5/2011, is hereby cancelled. Status quo before issuance of certificate in the airship certificate case, number 69 2011, is hereby maintained. Both parties are at liberty to approach an appropriate court for settlement of the instant disputes. So here, in connection with the airship case, the plaintiff was projecting himself to be the legal heir of the defendant number 1. And now he is fighting against defendant number 1, saying that he is the illegal occupant of the land, which was under 377 of 1978. And what we have stated before the trial court and even before the first appellate court is that he is barred by the principle of estoppel. He cannot blow hot and cold, saying that at one point of time he is trying to grab the property of the deceased Lalngena on the basis of airship certificate, which he was trying to, he had in fact obtained in connection with one LSC, which was obtained by the younger brother of Lalngena, who was in occupation and who was in continuous occupation of the said land, that LSC 529 of 2010. Now, he is fighting against the defendants number 1 and 2, saying that the LSC is without authority. Now, this is barred by the principle of estoppel, and he cannot blow hot and cold. This is what we have stated. And at the same time, what I stated in the suit as well as in the appeal before the first appellate forum is that the manner in which the transfer, the extension of the validity period was also not correct. It was illegal because the original allottee, Lalngena, had already died. If it was to be extended, it has to be, the airship certificate needs to be first issued. Otherwise, in the name of a dead person, after so many years, from 1978, no, from 1980 to 2002, that is after 22 years. After 22 years, he had presented the application in the name of the deceased. That was considered by the Revenue Department. And in the same year, on 27/6/2002, the Lord said, he had projected himself to be the inheritor, supposed to be the inheritor of the suit land under P Pata number 377 of 78, and saying that this is an application on behalf of the deceased, without mentioning that Lalngena had already died. So there's a fraud. Fraud was played at, for the purpose of obtaining all those airship. And in spite of all these things having been duly presented and stated in the course of the trial and even in the first appellate court, Lordship, the matter was not given proper attention. No heed was given whatsoever. And as a result, the impugned judgment was passed by the learned First Appellate Court on 1/4/2026. Lordship, we have projected here a number of grounds in an appeal. And on the basis of all this, Lordship, we have formulated the substantial questions of law. In fact, we have proposed for the purpose of formulation by the Honorable Court at page 13. May I take Lordship to page 13, paragraph 4. What I have stated is that in view of the above, the following substantial questions of law are found to be involved in this appeal. Number one, whether the learned First Appellate Court was right in upholding the judgment and order along with decree dated 18/10/2021 passed by the learned trial court, conferring right and title over the land under P Pata number 377 of 1978 in favor of the respondent number 1 on the basis of Mun Impegna Lekha, give deed, dated 27/6/2002, allegedly made by Sri Langena long after his death on 15/4/1980. The fact that